to our now new official home. We have actually moved in as of the first of this month. So we're glad to be here. Go ahead and call the roll.
Brian Crawford.
Here.
Jeffrey Foss.
Here.
Michael Newstrom.
Here.
Harold Perry.
Here.
Ewan Simeon.
Here.
Lenore Feedy.
Here.
And Jason Hannaman.
Here. As is our practice and custom, we'll start with pledge of allegiance. I pledge allegiance to the flag of the
United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
If I understand correctly, we do not have any comments on cards. Okay, so we'll skip over item number 4 on the agenda and move to item number 5. First item under number 5 is consideration of the April 12, 2018 minutes. Do we have a motion to approve those?
So moved. Second.
All in favor, say aye.
Aye.
Any opposed? The ayes have it. At this point, we have promulgated a potential route change to Chapter 8 per General Circular number 192. Is there any discussion of any potential changes as the rule was promulgated? Would anyone like to make a motion to adopt the change?
So moved.
A second. Let's do it by roll call vote, please, ma'am.
Brian Crawford.
Yes.
Yes. Jeffrey Foss.
Yes.
Yes. Michael Newstrom.
Yes.
Yes. Harold Perry.
Yes.
Yes.
The rule change passes because there's no tie and won't vote on it. All right. We'll move to item number 3, which is oral arguments on the motions by Miller, Hyatt, and Williams in the Miller, Hyatt, Williams consolidated approval.
One second.
Yes, I'm sorry, Mr. Chairman. The effective date of the rule change is effective today. There are some postings that could be impacted if it's effective after or effective June 1st, prospective effective date, then that will be after the test cycle on the 20th and the new scores come out.
Okay, so I suspect we want to post it today.
We would want to make it effective for June 1st.
June 1st.
So we might need to re-vote on that. Or vote on the effective date.
So we have a motion to make the effective date of the change June 1 of 2018.
So moved. Second.
All in favor?
Aye.
Any? The ayes have it. Thank you.
Thank you.
Now we'll move to item number 4.
So, just for clarification for the commissioner's sake, I've spoken with the attorneys, and the approach we're going to take to this oral argument is first that they will argue the motion to strike and the opposition to it. And then there are 4 motions for summary judgment, 2 of which are partial. They've labeled them 1 through 4, so they're going to argue them in that number so that it makes sense as you listen to them.
Good morning. My name is Michelle Gerard. I'm the attorney on behalf of the Department of Public Safety and Corrections Office of State Police.
Floyd Falcon on behalf of the appellants.
First, the department filed a motion to strike some documents that were attached to the motions for summary disposition filed by appellants in this matter. The department has relied on the Code of Civil Procedure Rules, Articles 966 and 967 with regards to summary disposition. And in looking at some of those documents that were attached, or one wasn't even attached, it was just an affidavit that was submitted separately. And so for those reasons, the department moved to strike the documents as set out in the motion, in that they're not certified copies of any of the documents, they're not reliable, they include newspaper articles, They include uncertified copies of policies and procedures. They include an unnotarized, what appears to be an affidavit, but it's not notarized, so it isn't an affidavit at all. And in moving to strike these documents, we ask that you do not even rely on them in the argument for the summary disposition. If the documents are gonna be allowed into the record, then we'd like to know that at this time, so we can address those documents as we go through them. We've outlined them in the motion. Do I need to read each one individually to you? Or are you familiar enough with it? I'm sorry. And there's, two of the motions specifically for summary disposition. In particular, I believe it's number, what we have labeled as motion for summary disposition number 3. It's a partial summary disposition. And it contains attachments labeled as State Police Policy and Procedure Manual 221, Louisiana Travel Guide, text message and photos, phone logs. I think this one contains an affidavit that is not notarized from Alexander Neskadinsky, a board of decision of the Board of Ethics, newspaper articles, and review logs. And because they don't comply with what evidence is allowed in summary dispositions in the Code of Civil Procedure, Article 966, we move to strike those, as well as the documents that we set forth in our motion that are attached to appellant's motion for summary disposition number 4. There's been an argument made that the Code of Civil Procedure doesn't apply to these proceedings, but we cite to the commission rules that say unless stated otherwise, they do apply. And therefore, we're under the impression that the Code of Civil Procedure rules dealing with summary dispositions would apply to this proceeding here. If not, let us know what the rules are, and we might have some extra evidence we'd like to introduce or bring some witnesses to testify on the motions, but we've relied on the Code of Civil Procedure in handling these motions, and respectfully ask that you strike the documents set out in our motion to strike in objection to the document.
Thank you for,
Mr. Chairman, if I may, I'd like to have your permission, instead of standing, sitting. I re-injured my back this weekend being an idiot working in my yard, and I have been in pain all week. And
having been an idiot many times myself, not just hurting my back.
Good morning. Just to address a couple of Michelle's preliminary statements. The affidavit of Michelle Hyatt was submitted in a timely fashion. We had a cutoff of April 6th to submit our motions. I was very conscious in discussing with Ms. Michelle Gerard that to get her the stuff as soon as possible. And as I was producing these motions and affidavits, I would file them and send them on. As opposed, because I can't stand to wait till the last minute in case the last day in case something happens. I couldn't get Michelle Hyatt's affidavit until the last minute. I mean, she couldn't come in to sign it until the last minute. I was exchanging information with her. But anyway, I emailed it in on April 6th at 10:34 in the morning. The cover letter says encloses the email filing of the affidavit of Michelle Hyatt in support of the motion. The original was being mailed today. So it was timely submitted in support of my motions. It just came in after I had filed the motions, but before the deadline for doing so. So that's my response to this. In regard to
You asked us to look at a fax filing of it as on that day.
well, I submitted the original, but
Oh, I
I
understand.
fax filed it, but I submitted the original.
Okay, thank you.
The second affidavit, and I have to take responsibility, is Mr. Ned Gazinski, who is not a party to this proceeding, but was one of the 4 people that were involved in going on the trip to San Diego, submitted 2 affidavits. And for some reason, I can't explain, and I didn't realize until I got the motion to strike. I just didn't notarize it. I mean, I notarized the other one. I didn't notarize one of them. Frankly, they kind of overlap in any event. But I got to tell you, I mean, it was just an oversight on my part in shuffling this stack of documents that was submitted in support of my motion. That was one page I didn't sign. Mr. Negazinski signed it. He signed it in my presence. And in shuffling papers, I just didn't notarize it. So that, whatever it is. His affidavit is simply supplementary or corroborative of the affidavits that was pretty much submitted by the other 3 gentlemen in any event. And it overlaps. In doing 2 affidavits, I did the first one, and then I was adding to the second one. I kind of recopied this, cited some of the same material in the second affidavit. So that's my fault. If I get punished for that, then I get punished. But that's the deal.
So can I just get a point of clarification, if you don't mind?
Sure.
I think I understood you saying that there is another affidavit.
Yeah, there's 2 affidavits, Mr. Negazinski. One is my Exhibit S, which I just handed to Ms. Lenore, and the other one is Exhibit I. The Exhibit I is dated on the 22nd of March. As you can see, I was trying to get them in advance of the April 6th thing. The second Negazinski affidavit was the same day. He actually came in and we did them. I had them both ready for him. I did them at different times, but I had them ready for him. Why I didn't notarize it, I don't know. Can't tell you. It just got caught in the shuffle list. My secretary told me it was 122 pages, so you got lost in the shuffle of 122 pages. But in fact, he did sign it in my presence. It was his sworn statement. But that be that as may. I did raise the issue in the opposition filed to, in the motion to strike filed by the Office of State Police. The statement was made that Article 966 governs motions for summary disposition. I don't necessarily agree that it governs anything. I think it can be looked at as an example. And I try to submit things in accordance with the same way we handle, and this is in the same way we handle motion for summary judgment in state court. And now, there was several things that Michelle points out, and I'd like to address those individual items, and then y'all do what you think is appropriate relative to those. But for instance, she complains that I didn't have the policy, and the Louisiana, the Office of State Police publishes on paper and in their, I don't know if you call it intranet, but with their electronic, within their organization, they publish policy and procedural articles. I attach a number of those policy and procedural orders that I got from Mr. Hyatt, who works in the policy division, and he printed them out off of the state police intranet, if we would call it that, and handed them to me. I didn't think and don't think that since they publish documents of the Office of State Police and public documents that I had to have them notarized, and I wouldn't have known who to get to notarize them anyway. But that's the origin. I don't think I have to do that for policies and procedures of the organization who is the opposing party in this matter. I would like y'all to note that there was no opposition or no suggestion that the policies and procedures that I submitted were incorrect in any fashion. I didn't want to. I have in my office a policies and procedures manual that I guess I got years ago from the state police. I didn't use that because I figured it might have been changed by then. I got Mr. Hyatt to print me current ones, and I suggest to you that there's been no statement in the motion to strike or otherwise that the policies as I cited them are not correct.
And certainly we would not think that you would do that, but just so that the record be clear, let me just ask that question. Is there any contention that there's any inaccuracy or incompleteness in what was attached to the document relative to the policies and procedures?
To that point, I can't testify. The copies that were attached have an effective date, and I haven't researched those individual policies to determine if those were the policies in effect at the time of the alleged violation. The policies are numbered, and like I said, it is a version of a policy. I haven't researched to see if it is the version of the policy or the only policy that applies to the issue in connection with this proceeding.
But that's something that could be addressed in briefing there. That is an issue.
Yeah, if it's an issue, I mean, I'm happy to try and get that corrected, but I believe it's correct. But thank you, Michelle. The same thing is true. There's a state travel law that's referred to in each of the 3 letters of discipline in this matter. Well, the state travel law wasn't attached to the motion, it wasn't attached to the letters of discipline, which is already in the record. But we got one, available on the internet. It's a publication of the Division of Administration. It was published. I even got a little bit more information on that. It said, if I could find it, it says, it even cites the PPM, and it was published pursuant to the Administrative Procedures Act, and it's available on the Department of the Division of Administration website. I didn't think I needed to get an affidavit to use one of that. The document they purporting to use against my clients, this is it. So I attached, and it's a thick document. It's a booklet. It's a booklet, and if we get to the merits of it, or when we get to the merits of this case, I suspect I'll have to get you the whole booklet. But I didn't want to have 40 or 50 extra pages in the record. I just took the pages that I thought were appropriate, and I copied those. If there's something wrong with that, I guess I'm a bad lawyer or something. The Attorney General's opinions are published by the Department of Justice. They on the internet. They published by the state of Louisiana. I don't offer them to say that these are factually correct, but this is akin to a case. I cite a case that's published by the West Publishing Company from the Louisiana Supreme Court. Well, this is published by the Department of Justice, and it's a Department of Justice opinion for whatever weight it's entitled to. It's, but it deals with some of the same things. So I'm offering it as not a factual affidavit, the truth of which is, but it's. I'm telling you, it is the opinion that's published from the Attorney General's office, and I cite it simply as supportive argument. I'm sure there's plenty of those opinions I don't agree with. I happen to agree with these. And I think then we have, Michelle has made me do a little research, which is I'm bored doing. But we come to the newspaper articles. We have two different things here on the newspaper articles. We have Mr. Mustang and Mr. Zerg have been hot on this story from day one, and at least since it all broke in 2016, and I attached some newspaper articles, and another attachment that I propose to make. This Office of State Police put out a news release. It's an official news release put out by the Office of State Police by Mike Edmondson when he was the commander of the State Police. And in his affidavit, Mr. Hyatt, Mr. Williams, Mr. Miller talk about receiving or seeing that news release, and also talk about there was a television news event on the same day indicating that on February 18th, 2017, the then colonel, appointed excuse me. Major Flincham, I'm sorry. Now retired Major Flincham to conduct an internal affairs investigation of this matter. Well, I'm not so much interested in the news article that's reported in the paper or the press release made by Colonel Edmondson, but I am interested in that it happened on February 18th, 2017, because that's at the heart of my argument insofar as whether this is timely or not. So that's the one that's important to me. But I wanted to tell you, in regard to the admissibility of newspaper articles and news releases of this type, I think if you look at the Code of Evidence, Article 902, Section 6, extrinsic evidence of the authenticity as a condition precedent to admissible is not required with respect to newspaper articles and periodicals, printed materials purporting to be newspaper articles and periodicals. I would suggest to you that that article of the Code of Evidence, if you notice in my opposition, I thought Michelle was right, frankly. In my opposition to the motion to strike, I start off by saying I think she's right about the, I'm not trying to pull, I try to be as straightforward as I can. I say in my opposition to her motion to strike, I believe she's right about the Zurich and the Mustang articles in the newspaper. But I was arguing a case in court on Tuesday, and one of the lawyers in that case this is complete coincidence to me, wanted to put in some newspaper articles, and I objected. I said, you can't do that. And he points out to Article 902, Section 6 of the Code of Evidence. I said, I better go read that. I said, I made myself a little note. I better go read it and see what it says.
Do you have a copy of that article?
I do not have a copy on. I have to quote from it, but I don't have a copy with me. But in any event, that was insofar as the authenticity. That it only relates to authenticity. Now, in Colonel Edmondson's statements, which is the thing that I'm really interested in, because that firmly establishes February 18th, 2017 as the date we're dealing with. It's covered in all three plaintiffs' affidavits, appellants' affidavits. They saw it on TV. They read the newspaper article all on the 18th, where the colonel said what he said. So insofar as in the objection, and it would be hearsay, statements against interest, and certainly this is a statement against the interest of the state police, statements against interest are admissible as an exception to the hearsay rule. So I believe
Can you
Colonel...
explain how that would be a statement against interest and simply make a statement that that's when you call it an investigation?
Well, if y'all buy my argument, if we use February 18, 2017 as the start of the internal affairs investigation, they didn't finish it in 60 days, they didn't finish it in 90 days.
But at the time the statement was made in February, how was that against his interest?
Well, I believe shortly after that got fired because of his handling of this entire deal. I think that's pretty much against his interest. But I think it's a close question, Mr. Simeon. I'm here making arguments to the best of my ability, and I'm not suggesting that this is lock cinch for sure. But the bottom line is, do y'all have any doubt that if we can subpoena Colonel Edmondson, and if Colonel Edmondson shows up, he's gonna say, yes, I sent out this notification to the newspaper? Because I saw it myself. I didn't give my own affidavit, but I saw it myself on the news. And he started an investigation against my people. So that stuck with me. But, you know, if I don't get it in through the newspaper articles, I couldn't get Colonel Edmondson here today. I can't subpoena somebody. If we're going to use 966 as the template in this matter, I can't subpoena somebody to come and testify to motion for summary judgment. So, but I will subpoena him to come and testify at the trial, I can tell you. So that was that. And then, let me see, I think there's one other point I wanted to make regarding the motion. Michelle also, I'm sorry to say just me. Michelle and I have been doing business together for a long time, so we're all on a first name basis. Ms. Joa and I, in her memorandum, in Ms. Oakland's memorandum, they make an argument that the affidavits are conflicting. And they use for an example that in our affidavits, the appellants, each state, Colonel Edmondson said something, and Colonel Dupree said the same thing. Now, it's in two separate articles, two separate portions of the various affidavits, but they use that to say, they speculate. They say, we are suspicious that because you say they said the same words. Well, that goes to the weight of the affidavit, not to the admissibility of the affidavit. You don't strike an affidavit because you don't agree with something. What you're doing is, the heart of this whole thing is, and we're going to get into this when we start arguing the motions, they can say what they want in opposition. If they want to oppose something that's in the affidavit, they have to submit a countervailing affidavit. And that's where they failed pretty horribly in this matter in the opposition, because they say three affidavits, but they don't countervail much. The statement was, I'll find that when we get to the argument, but if they don't agree with something in the affidavit, it's not the subject of a motion to strike, it's a subject to submitting a countervailing statement. And that's the point I wanted to make in regard to that. And I think that responds to the motion to strike the best that I'm able to do it.
If we could, I need a point of clarification, Mr. Falcon. When you filed all the separate motions and the opposition to the motion to strike, you had exhibits that were numbered numerically. Today, you handed us an exhibit list with exhibits that are listed alphabetically. And so the exhibits...
Same exhibits. Let me say
You
this.
don't have the exhibits that you presented today, do not have the exhibits of the news articles of Mustin and Zurich. At least I don't see it in here.
And I didn't do that because I thought Michelle was right. I thought she was right. I do have those, and if you're willing to let me supplement, I'll be happy to supplement. They were parts of the affidavits that I submitted to y'all. But in trying to spend the last 3 days preparing for this argument and putting my documents in order and so forth so I could make a little bit of sense, I took those news articles out because until Tuesday I thought they were absolutely right that I couldn't put in the newspaper articles. But Tony Clayton taught me a little different story on Tuesday.
So exhibits 8, 9, and 11 were originally filed of record. They're just not presented with this fact today that is alphabetically listed, just for commission.
That is correct. Y'all have
And then all of the other numerically listed exhibits that were previously filed of record are now alphabetically listed today. So
right. If you look at my initial index with number 1 was motion for summary disposition number 1. I call that my number 1.
Right.
Affidavit of Rodney Hyatt regarding the Reeves promise was number 2. Well, I didn't, as an exhibit, I didn't put in my motion. I extracted my motion because that's already filed in the record. I was trying to figure out how not to have more than 122 pages of paper. So what I did is the new numbers are ABCs, but they correspond. And, to make it simple, let me give you a copy of my index.
Okay.
And I have the exhibit numbers on the
Okay.
index.
Okay.
And I think let me give you one too, Michelle. That way you can follow them.
Is the news release on the stack that we have?
The news release is,
The news release.
it's listed as Exhibit U now. It once was Exhibit 10.
Right.
I think.
That's correct. Let's see, the news release is here, I think. That's right.
Well, you have it as 28.
I have, it is 28.
Okay.
But you see, as in that particular motion,
Okay.
it was 10.
It was 10.
It was 10 attachment to that particular motion. But what I've done, since the affidavits and so forth, or the information we're submitting in support, kind of overlap between the motions. Michelle designated the motions 1 through 4, and after she did that, I fell into doing that too, and then I put all my I made all my exhibits and responses in globo in one,
Okay.
all in opposition. But I think that'll help you to
Okay.
follow.
Thank you.
So I think that's all I have in regard to the motion to strike.
Would you like to rebut his argument?
I think, and I want to make this as simple for the commission as possible, so if it's easier to follow his exhibits with the way he's labeled them today, and we want to rely on that, and add those in there for argument's sake, I'm not opposed to adding it in for the purpose of argument's sake, and just point out that the last exhibit on the whole exhibit list is labeled as appellant G, and I believe it should be GG. We went through the whole alphabet there, and
Yeah, it should be GG.
But it's kind of difficult referring to them because there were 4 separate motions and there were different documents attached. But just in response to that, we stand behind the premise that the Code of Civil Procedure designates what is competent evidence in a motion for summary disposition. And the things that we point out in the motion for summary disposition is not competent evidence for it. With regards to the affidavit, the argument is correct. It does call into question the credibility. We pointed out somewhere in all of our oppositions that when you're dealing with a disciplinary action, you do not have those pretrial procedures available, such as depositions or other forms of discovery that you do in other civil trials. So it's really hard to deal with issues without having those procedures, because you're relying on affidavits, and when you have affidavits that in and of themselves contradict what's alleged in the same affidavit or other people's affidavits who are parties to the same proceeding, it calls into question the credibility of the affidavits. And while I understand what he's saying, don't strike the whole thing, but it goes towards the credibility of what's in there that they're relying on to dismiss this whole proceeding. And that's the point of it, is it's not credible or competent evidence, and it shouldn't be considered.
Just a question for you. But if, in fact, there are some inconsistencies in the affidavit, would we not be better off by not striking it, but simply saying it doesn't support the fact that he's trying to let it support, and therefore there may be a disputed fact, and therefore we can't dismiss by summary disposition? Would that be a better approach?
That's a whole nother argument there that we intend to make, is with regards to summarily disposing of this matter on the motions. But just pointing out that the affidavits are inconsistent, it calls into question whether, in our opinion, whether it's competent evidence to even be admitted into the record.
Thank you. Just 1 second. Please refer right on counsel. Trying to make lawyers out of all the commissioners here.
And it's difficult for us as lawyers. Lloyd and I have been talking about that.
We were just kind of like, that's exactly what we're asking you to do, and I understand that you have to get advice and consideration.
And I will make some suggestions to the rest of the commission. Obviously, they're free to make their own decisions on this as we go to vote on any of these. But are there any questions from any of the members of the commission?
After they have to notarize these submitting these proceedings to maybe to do that, like after they say notarize there's under discussion, they have to be notarized in fact.
Well, that's one of the things we may have to decide, or we may have to decide whether they can be a cure to that issue.
Real quick, I guess maybe this is for you, the chairman and legal counsel here. The initial question was, do we have to comply, or does this whole proceeding have to apply to what the state has already said in terms of civil procedures? Is that question been answered?
It's not been answered with respect to this commission, and counsel cited a case involving the ethics board, and so, but that's a state agency, but they also, talked about the Administrative Procedure Act in that matter, and we don't have to follow the Administrative Procedure Act because the commission has been empowered to create its own rules.
But it's 2018, everybody knows that, but you're saying that this question has never come up in anything dealing with this commission?
I have not seen where it's been decided that the motion for summary judgment rules are applicable to state police commission, matters.
Mr. Newsom, I can just say from my own experience, I've been here 20-something years, through a lot of commissions. And, it never came up before to my knowledge.
But there's a lot.
What has been the practice then? What has been done? I mean, what's the precedent? Is there a precedent?
I would like to speak to my experience. I've never had a case where a summary disposition to this extent has been filed. Most of the summary dispositions that I've dealt with, the most recent one in a case dealt with the letter itself saying the evidence was not attached to the letter. And so that's kind of a notice issue. We've never had, in my experience, and like Floyd said, we've been practicing together, we've never had summary dispositions to this extent in disciplinary cases before this commission. But I'll point out the commission rule says, unless otherwise stated, the Code of Civil Procedure applies.
It says the rules of evidence apply in Rule 13.11B.
And can be lightened up on.
And
that was the point I was making,
It talks
sir.
also about where appropriate and not inconsistent with these rules, hearings and the taking of testimony shall be conducted according to the accepted practice in civil trials. It's silent on the actual issue of the applicability of motion for summary judgment, civil procedure rules in these proceedings.
I understand a little bit.
Y'all are the
I
hope you
think it's
do.
new ground. I think it's new ground. I think,
Yes.
they're looking at the commission to make a decision, but it's a broader issue.
Mr. Newsom, if I could say, we don't normally have, and this is certainly a fair statement. I spent a whole lot of time. We have a 5-day trial in this matter set in July. I'm trying to the best of my ability to highlight some of the issues that I have in hopes that some of these issues will be washed out and we won't spend 5 days. We spend 2, I'm hoping, or something, or 3, but not 5 days beating this dead horse. I don't think there's going to be a whole lot of factual disputes in this case. Frankly, when it all washes out, it's gonna boil down to what Colonel Edmondson said and what Colonel Edmondson did, I believe. That's my theories. And that's the theories that I argued with the Board of Ethics about, and that's the theories that I argued everywhere I could argue that point. What I did is to spend, Ms. Feeney had a status conference with us, and she rightfully said, okay, let's get all of y'all motions in advance, because most of the time we take up a motion for summary disposition at the beginning of a hearing. Well, that wouldn't make much sense if we can ferret out some of the issues in this case and shorten the 5-day deal in July. We wanted to do it in advance, and she set a schedule for us to file motions by April 6th, I believe was the date, and set a time for us to have this argument today, May 10th, and that was the appropriate way to do it. The motions we filed are much more extensive than the motions we file in a typical case. I gotta tell you. But, for instance, let me say, I have 2 really, what I say are really serious motions, the Laudermill issue and the timeliness issue. That's 1 and 4. But in regard, a typical motion we file in these types of cases is the rules, y'all rules talk about notice, presenting the evidence in advance, or going over, giving us an idea what the evidence is Because as Michelle said, we don't have discovery, we don't have interrogatories. So we have to get everything we're gonna get to prepare a defense in accordance with y'all rules. They have to give it to us in the notice. In number 2, I cite, and fortunately this is kind of strung out along because I'm dealing with 3 defendants or 3 appellants who have slightly different allegations against them. So I had to kind of repeat myself. I found myself in doing this that I was repeating myself an awful lot, but I had 3 people to deal with, you see, 3 sort of different sets of facts. So this is far, far more extensive than anyone I'd ever been involved in, to tell you the truth. But I made the effort because I thought we could sharpen some of the issues, get things trimmed down a little bit, and have a much more cogent presentation from the standpoint of the Office of State Police and from myself, or from the standpoint of the appellants, at the hearing in July, if we could trim some of these issues and we don't, kind of let us know what y'all want to hear about, and we'll try and make that presentation and let you come to some agreement. This is difficult. I mean, this is difficult. I remember when Loudermill came out, I think it was in 1986. I mean, we had all kinds of pushings, and Loudermill sort of has evolved, and Loudermill led to y'all amending some of your rules, and all that's good. But I mean, it has, as you mentioned, it's 2018. This has evolved since I've been doing this since, in the 80s. So that's where we are.
Well, Norm, let me ask you something. We're looking at, sorry, Mr. Chairman.
Well, just briefly, if you don't mind, if you want to make a comment relative to what we just said, so we'll keep that together.
I agree with Mr. Falcon. This is more extensive than we've ever dealt with. The facts, my opinion is, the facts can be hammered out in a way other than this motion for summary disposition. It's actually partial summary disposition through other avenues available, like stipulations of fact. I mean, the parties could sit together and go through the letter line by line. If you read the affidavits, compare them to what's in the letter, a lot of the conduct that is the notice part of these letters is not disputed. They took the trip. They stopped at the places they're alleged to have stopped. They charged the expenses they're alleged to have charged. They filed the timesheets and prepared and filed the timesheets they're alleged to have prepared. To me, that's the heart of the facts. That's what notice is. This is the conduct you're accused of being engaged in. That's the notice. The other part of the disciplinary action is cause. What's stated in the letter, the notice given of the conduct, is that cause for any discipline. We don't even get to the severity of the penalty. And that's the crux of 2 of the motions for partial summary disposition. But once again, we don't think there's competent evidence in the records of these motions to say the notice provided wasn't sufficient. The way to whittle down what you guys are going to hear in July is for the parties to get together and do stipulations of fact or statements of uncontested facts and present that to you. The rest is argument. Did it rise to the level of a violation of policy and procedure, and what discipline is appropriate? Those are issues that can't be disposed of on a motion for summary disposition. I don't think that's the proper procedure to go.
If I could give you one
You
example.
don't want to get into the merits
of the motion, but
the
if I
motion.
could give one example, it might be beneficial.
Does it relate to the
What
issue?
she just said.
Well, but some of what she said and what she said earlier really are getting more into the merits of it. I mean, we need to right now focus on the question of striking these particular documents if y'all begin on that. But anyway, I think we had a comment from one of the commissioners.
Thank you,
Question.
Chair. I just wanted to be clear, in front of the board right now, before we get into some of the other complex issues, which I don't believe we're going to get to today, what is before the commission today is simply the appellee or DPS asking for a motion to strike documents submitted by the appellants in their motion for summary disposition. Is that correct?
That's what's up right now.
That's what I want to be clear about.
And then
Seems
after
like
that,
really-
we're gonna have them argue on the 4 different motions that are before. But right now is a motion to strike.
Okay, and And with that motion, just from my perspective, I'm in agreement that LSPC Rule 13.11 allows the rules of evidence applicable to civil trial proceedings. This is not a court of law. And so I'm going to make a motion at this time, Mr. Chairman, that appellee's motion to strike documents submitted by appellants in their motion for summary judgment be denied.
Okay, would you, is there a second?
I say that motion.
Perhaps what we ought to do, and this is just a suggestion, is maybe take each one of these on a line item basis rather than do it, unless the heart of your motion is basically you don't think any of this should apply, therefore, we just.
I don't. I think specifically citing the rules of evidence applicable to civil trials. Again, this is not a court of law. I think that the commission is smart enough to differentiate between if something is controversial or contradictory in a document, that we can proceed through those documents and you'll have an opportunity, or DPS will have an opportunity to speak to those documents. But I don't see how taking away a document that could potentially provide this body with more information could be harmful.
Okay, couple of questions, and certainly we have a motion, so we're going to open up for discussion. Couple of questions. One, I don't know that we necessarily, in order to rule on the motion to strike, whether it be to deny it or to grant it, or to grant it in part, have to necessarily adopt a stand that Article 966 Louisiana Code of Civil Procedure applies in this instance, because I think it's pointed out by our counsel, the rules are at least ambiguous on that point. But sometimes there are certain things, whether we're a court of law or not, that may be appropriate to consider, and certain things that might not be. For example, the first item that comes to mind would be the newspaper articles that the Mustang and Zurich newspaper articles that are written by individuals who have not produced affidavits, who have simply made statements as news reporters rather than as someone who would have relevant evidence that we should consider in determining whether or not there's an undisputed set of facts, and whether under that undisputed set of facts we should find, if we were to go with the appellant's argument, we should find that there is no rule violation based on this undisputed set of facts, which is one of the ways we could, if we were so inclined, to summarily dismiss this. And so I just question whether we should rule on this from a general standpoint, and just simply rule on it or we should look at each of these items on an individual basis. That would be my comment.
Do you have a motion and a second?
We have a motion and a second. Any more discussion?
Yeah, I'm not comfortable making a vote in either way at the moment, because some of this I've read the documents we've been provided, but sort of a closer analysis of everything is kind of new, I guess. And listening to the arguments that were just made, I would rather, if we can do it, have more time to kind of sift through it and ask more questions of you. That's my feeling, before we just reject it and say, go that route.
Okay, we did not announce, obviously I'm hearing some concern that we need to consult with our lawyer, but we did not put it.
Chairman, I can withdraw my motion until we have more
Well,
time.
we don't object if you want to go into executive session. I was amazed that wasn't in the agenda.
We can't go into executive session. It's not noticed, and it's not, there's not a basis for it under the law.
Well, to consult with our,
About wrongdoing?
no, I mean to consult with our attorney, but.
Yes.
But yeah, it wasn't noticed. This is what the problem is.
My point is, I don't have any
I'd be
objection.
willing to make some suggestions
I
here.
believe, as the member making the motion, I can withdraw it.
You
And
certainly.
I'll do that at this time, Mr. Chairman.
All right.
So
Let
we
me-
can't talk about it amongst ourselves.
You can talk about
We
it
can talk
here
about it right now.
out loud right
Let
now,
me,
too.
let me make some suggestions, if y'all don't mind, if that's in order at this point. I think that the issue with the news, this is just my personal view of looking at this. I think the issue with the newspaper articles is problematic to allow newspaper articles to come into a proceeding, whether we adopt Rule 966 or not. The authenticity issue notwithstanding, there are issues beyond authenticity that are related to newspaper articles and us considering such documentation in our evaluation in a summary disposition. The affidavit of Ms. Hyatt was sent, and I don't think there's any dispute about this, was sent on a timely basis by way of fax. I don't think there was a dispute about that. So I don't see where that's an issue. And this, I'm just giving my personal views so we can discuss it. I don't see that as an issue for our consideration. The Board of Ethics decision is a public document that can be cited, could have been cited, whether it's attached to the motion or not. We are not going to ignore, I would not ignore, in my opinion, I would not ignore a public body decision, and I think it's appropriate for us to consider it. The manuals, once again, if there's an issue about whether or not they're the appropriate manuals for the date and time of this particular incident, that's something that can be briefed on the question of whether they are the right statements of what the manuals provided at those dates. I don't think the manual should be stricken. The Attorney General opinion, I think it's an Attorney General opinion, it could be cited in a brief. Whether it's attached to a brief or not attached to a brief, we would have to take cognizance of what the Attorney General opinions are. Not that we have to agree with those, but we would have to take cognizance of those. It's simply a matter of convenience to attach the Attorney General's opinion to it. The exhibit for partial summary judgment that was not notarized, I would suggest that there be an opportunity to correct that flaw. I mean, obviously, we take Mr. Falcon at his word. It was signed in his presence, and if he will notarize it, he can cure that particular problem. Relative to exhibit number 10, which was the Office of State Police prepared by the Department of Public Information. That's a statement by the department. Without getting into whether it's a statement against interest or not, it's a statement by the department. I would suggest that we would consider it. My suggestion would be that we strike from the motions, the newspaper articles, but the rest of the motion is strike, be denied, for those specific reasons.
The newspaper articles of Zurich and Mustang.
The newspaper articles of Zurich and Mustang, not the news released by the department.
Is that a motion, Mr. Chair?
Can I make motions, or does somebody else have to make motions? If no, I would just move that they to adopt what I just said.
I would adopt what the chairman said. I don't know if I'm in the first year of law school or second year of law school, but I'll just say this. To be fair and impartial is all this board wants. And have all the facts presented before us so we can make an educated decision, and the technicalities can be argued amongst the lawyers, whether it should be submitted or not. But I believe submit everything and let the facts be what they are, and we're educated enough to figure out what was right and wrong and what took place during that event. That's my take on this.
Do we have a motion? Do we have a second?
Second.
Who made the motion then? No, I don't. You made the motion, you second. Okay. Any further discussion? All in favor, say aye.
Aye.
All opposed? Okay, the ayes have it. So please correct the deficiency relative to the affidavit. We're striking the Mustang and Zurich articles.
Thank you, sir.
Just one second.
take a 5-minute break for break?
That's fine. Yeah, that's fine. Probably everybody needs that. Probably you had me thinking I'm teaching law school today. What's the next item?
Now, in accordance with our previous plan, we'll start out with argument on the first motion for summary judgment that all the parties have agreed is the motion number 1.
So, Michelle and I discussed, so that the record is clear, we would like to offer and introduce the entire record in this matter, including the petitions for appeal and the letters of discipline that are attached to the petitions for appeal, with the attachments to those letters. They're already part of your record, but just wanted to make that formally. And I would offer, introduce, and file exhibits A through GG.
And just so the record is clear, we had there was mentioned earlier, and we had an off-the-record discussion that excludes the Mustang and Zurich.
They're not in the exhibits A that I produced today, because I didn't think they should be here.
We have no objection.
If we could, the second thing Michelle and I talked about is that we thought we would mention that I'm prepared for about a 2-hour argument here, and that we have decided that we are going to try and extensively limit our argument to the highest points and allow you all to refer to our brief, our memorandum, in support of our argument, because as I said earlier, I found myself saying the same thing over and over again in several other places. So we're going to try and keep that. The first matter in this is motion for summary disposition, which we've called number 1, which I, in my documents, refer to as the Loudermill and Rule 12.7 argument. The Loudermill case was decided in 1985 by the United States Supreme Court, and it kind of changed the way these proceedings dealing with employees with a proprietary interest in their job, in other words, classified civil servants, tenured teachers, people that have a property right to their job, how they're treated insofar as any type of disciplinary action. And the court basically ruled that employees should be given notice and some type of hearing before the actual deprivation. In other words, they should have at least a little preliminary meeting with the employer in order to have, and this is a quote from the Supreme Court language, an initial check against mistaken decisions. If, for instance, something is alleged to have, an investigation takes place and they said on such and such a date you did such and such. And if the employee could then show that on that particular date he was in New York City, not in New Orleans, we don't go through all the rest of this, you see. So the courts, and they've had a number of cases that come down interpreting Loudermill, et cetera, which again deals with due process, deals with notice and an opportunity to be heard.
But what is your contention as to what the Loudermill violation, if any, was in this case?
Well, I want to make it clear. In the normal case, the rule and the Loudermill case simply say that you have to give me notice, and we're going to talk a little bit more about whether the adequacy of that notice in another motion. But they gave us notice. They gave us some notice. What I'm saying is they didn't give us a reasonable opportunity. This is my point, and I can make it very short, briefly, and clearly. There are 2 affidavits, Williams and Hyatt, in which they say that they received their Loudermill notice and the attachments from their superior. It was handed to them, no discussion. And they contacted Colonel Reeves. And Colonel Reeves, they asked Colonel Reeves, look, we would like to have, because in a normal case, and in every state police case, there's a provision that says, well, you need to respond in writing to this proposal, the Loudermill proposal for disciplinary action. And in every case since Loudermill, or at least in the last 20 years, we never challenged that before because there was an opportunity to submit written documentation to the colonel and let the colonel decide based. So that was the initial check. You can submit. Well, in this case, it's different, and I think we have to look at this. In this case, I submitted 2 affidavits that Hyatt and Williams talked to Colonel Reeves, and Colonel Reeves promised them, before I make any decision in this matter, I will meet with you and give you an opportunity to discuss the issues with me and to present additional evidence. If Colonel Reeves, and I have to applaud Colonel Reeves, he submitted an affidavit in this matter, and he didn't contradict that. He didn't contradict that statement. What I'm arguing, what I'd like y'all to consider is this. Nobody's holding a gun to the colonel's head saying, look, you have to meet with me. We should get special priority or preference over and above what other troopers have got over the years. Colonel Reeves offered to meet with these people, discuss the matter with them, take additional evidence from them, and do all of that before he made a decision. He did that, deny that. When Darrell Williams and Rodney Hyatt spoke with him after in October, when they got the determination and the disciplinary action that they would be suspended, they went asked Colonel Reeves, why didn't you let us?
I'm going to object. Is this testimony, is this argument as to Loudermill? Because none of that's in the affidavit, the discussion in October or anything like that. To present additional testimony through counsel, I don't think is appropriate. The affidavit refers to meeting Colonel Reeves at headquarters, asking for a meeting, not the colonel didn't offer. So let's use the right words. He didn't offer a meeting. And then it just says they were demoted without having the opportunity to present evidence. That's what the affidavit says.
Excuse me, I disagree with that. So I will cite the affidavit to you. It's the second Hyatt affidavit. It is Exhibit P. Citing the wrong way in Hyatt affidavit. Excuse me.
I think we have it as G.
We can review the affidavits and see what the affidavit
All right.
said. If it's not in the affidavit, obviously we're not going to consider it.
I agree. It is in one of the. It's in one of the affidavits. It's in several.
If it's in there, we'll look at it. If it's not in there, we won't look at
That's
it.
correct. Anyway, it goes on to say that the colonel, when he was asked about it, he said he forgot. Well, that's not good enough. If you promise somebody in accordance with the rules to give you a reasonable opportunity. Now, I have to tell you, I want to be honest with y'all. In the past, I don't say that the opportunity to submit something in writing is unreasonable and doesn't comply with your rules or doesn't comply with Loudermill. What I am saying is this: if you ask somebody for an opportunity to meet and they agree to it and say we will meet before we make a final decision, you will get an opportunity to discuss the issues. You will get an opportunity to present evidence, and you don't let me do it, then I have been denied my reasonable opportunity to respond to the charges against me in a pre-deprivation phase of this proceeding. And I believe that is contrary to Loudermill. I believe it's contrary to your rules. And basically, that's my argument regarding Loudermill. I don't want to suggest to this commission that I think that the normal procedure is inadequate, because I'd have challenged it a long time ago if the normal procedure was inadequate. But in this case, Colonel Reeves, and I got to say for Colonel Reeves, one of the first cases one of the first disciplinary cases he has to handle when he comes on board. And you know, he put his foot in his mouth. He said, I'm going to give you all this opportunity. And he didn't. Might have got advice. I'm speculating. But in argument, I guess you can speculate. I kind of speculate somebody told him you shouldn't have done that. But he did do it. And we relied upon it. And I think he's bound by his argument. So I believe for those reasons, I think that the motion should be granted.
Can I ask this question?
Yeah.
In a nutshell, your argument is that although the rules don't necessarily require that meeting, because Colonel Reeves said he would, he can in fact create this due process right.
Detrimental reliance.
That would be your argument.
That's the argument. Yes, sir. I could have said that if I wasn't trying to educate Mr. Foss, you know, get his second year in the law degree. No, but detrimental reliance. You promised me, you didn't do it. Shame on you.
And the department vehemently disagrees that any statement, even if Colonel Reeves did make this statement, I will meet with you, that not meeting with these employees was to their detriment. They adequately responded. They had 3 months to add any additional information, either to internal affairs to supplement what they provided during the investigation or in a written response, and that wasn't done. This case is no different than any other disciplinary case. These employees should be treated the same as other employees, and I think the record shows there's no detriment. They did respond. Even in their affidavits and all the motions, there's nothing new in there that wasn't said in the responses. And I don't think that if the statement was made, I'll meet with you, it creates any additional due process rights. And we cite the Savoy cases and the Lombas cases to show that, you know, no additional due process rights were created in this case. And we ask that you deny the motion.
In Savoy, they met personally twice with their supervisors and got exactly what they were promised. The affidavits, I'm quoted the wrong affidavits, is Exhibit A, Rodney's affidavit, and Exhibit B, Darrell's affidavit. It says in paragraph 2, on July 13th, after he had met with Reeves and asked for a meeting to present facts relative to the side of the story and to demonstrate the inadequacy or inaccuracy of the internal affairs report, which was the subject. That's how they generated the Loudermill notice, because they followed the internal affairs report. Colonel Reeves told Hyatt and Williams that before he made a final decision, he would meet with them and grant them the opportunity to discuss the issues and present their side. I didn't make this up. I mean, really don't think I'm making up anything. It's in this affidavit, I promise you. It's in A, it's in B, and I expected, I was interested to see when I got Colonel Reeves' affidavit if he was going to really try and countervail that. I applaud the gentleman. He didn't do it. He didn't countervail it, and rightfully so. He was honest.
So boil down, you're arguing detrimental reliance and or an expansion of due process by
Right. That's
promise that was
exactly right.
made, And your position is, one, even if there was reliance, it may not have been detrimental. And secondly, there can't be detrimental reliance and to create additional rights more than due process requires.
In a nutshell, that's.
All right, that's good. That's what we want to do.
So that was about a 30-minute argument reduced to 5 minutes, so.
We commend you. We commend you.
I thought I'd give a whole lecture on the Lauderville case to start, but and how it resulted in the adoption of your rules.
Are we doing one at a time?
I think for clarity, one at a time, where he argues, the first motion, they oppose, reply, then second motion, oppose, reply.
Yeah. So I'm gonna move on to the second motion. So I call the second motion.
Wait, y'all
Make a
wanna vote?
decision on each one that is presented, can we do it that way? So we don't get bottled down with.
I would think we might need some additional guidance from our council. And these motions don't need to be ruled on today because the other need to be ruled on so they can know what they can rely on. These motions we can rule on at the next.
We would hope we would get a written response to the motions too, because this is an unusual case, and if we could get a written response so we know what we're dealing with in the future.
A written decision?
A decision, yes.
Yeah, we would issue one, but it may not be voted on until the next meeting.
So,
And we could issue it at that point. Is there a question of that?
I do. I'm just trying to figure out if we have a position on the evidence that we've heard today and what we've read, waiting until the next month, the purpose is for additional legal clarity?
Legal
or-
clarity, yes. To get some input from our council.
the second motion is a motion for partial summary judgment as it relates to particular items in the three disciplinary proceedings. And the motion is long because it addresses various things, some of which are the same, some of which are different. But I'm gonna try and hit the highlights. Y'all can read the motion and make a decision on that without me repeating everything multiple times. So I'm gonna try and do that. But one of the issues is not taking the most direct route. One of the charges is not taking the most direct route from San Diego to Baton Rouge. I don't believe that there was in conjunction with this matter, your rule 12.8 deals with written notice. It says it must fully inform, the notice must fully inform employees of the conduct on which the action is based and which will enable him to prepare a defense. As Michelle has already said, and I reiterate, we don't get discovery, we don't get depositions, we don't get interrogatories in this matter. We stuck with what they sent us. So my argument in trying to make it as concise as possible with this is, and I submit affidavits, but I'm interested in telling me what happened and what policy was violated as a result of this happening. That's what I'm looking for when I want to prepare a defense for my clients. Now, we have a whole lot of facts and we have 10-page letters of demotion and so forth with attachments to them. But it kind of all boils down to looking at each set of allegations of fact and whether or not they tell us what policy was violated by that. And I'm saying if you don't have both elements, you don't have in your notice what set of facts or a statement of facts with full particulars, the date, place, name, people involved, full particulars, and then an explanation or an indication of what policy was violated by that set of facts, then I suggest to you that pursuant to Rule 12.8, we've been not fully informed of the conduct of which the action took place, enable us to prepare a defense. I cite in my motion specific things. For instance, I cite, the letters failed to state what policy or prohibition prevented a trooper from amending his time. And I suspect that Trooper Foss might be able to give you all a little insight into this. But it is not unusual for a trooper to submit a timesheet and then have to correct that timesheet. Well, these people did that. There was an issue in the regulations as what it means to be in transit. If you're in transit, you know, these fellows didn't normally take a 4,000-mile trip across the country. If you're in transit to Lafayette, we probably got a pretty good clear that you go to Lafayette and then you come back from Lafayette. If you have multiple days and you have overnight stays and so forth, what does it mean to be in transit? So I've looked and I don't see anywhere in the letters where it explains how many hours, if you are away from home traveling for 3 days, 12, 14, 15 hours a day, how you figure out how many hours you use. If you stop to go to the restroom, or you stop to get a meal, or you're still in transit, all of that's not clear from his regulations. Captain Graffia sent an affidavit. They submitted their initial timesheets. Captain Graffia says, y'all got this wrong. You can't claim the full time you're gone in transit from one place to the next place. You can only collect when you're actually traveling. Well, I'm not sure if that's true either. I never got that from reading the regulations. Because if you stop to go to the bathroom, or you stop, the example that's pertinent to this, they claim that they went to the Hoover Dam. Well, they didn't even go to the Hoover Dam. They passed by the Hoover Dam and viewed it from a roadside stop. That's what happened. They viewed it from a roadside stop. Well, can you go to the bathroom? And can you, while you're there, take a picture? Or can you take a break from driving 14 hours in a car? Can you get out and walk around? I think, that, but all of that is factual. The point I'm trying to make is they amended their travel time. They amended it. In some cases, they amended it more than one time. No policy or procedure was cited to say that you can't amend your travel time. I submit an affidavit, they say that it is routine that you do that. That would be something that has to be ferreted out. We didn't have any opposition to that in the memo, in opposition saying that you can't amend your time or amend your expense statements. If there's a provision against doing that, and if it's not done on a routine and regular basis, show me the policy that says I can't do it, because it is done regularly. That's one of my main arguments in regard to that, but I'm dealing with specific things. I go on. So that was travel time. Same thing, travel expenses. We fought all. This is kind of ridiculous if you ask me, but the initial.
Yeah, are we on number 2, or are we dealing with number 3 right now?
They're kind of together. Actually, 2 and 3 are together.
Yeah, because you're going into the
2 and 3. I mentioned earlier my most significant arguments are 1 and 4. The individual nitpicking arguments as to specific allegations are in 2 and 3.
As long as you realize that you're arguing 2
I
and
know
3
it.
right now, we're not going to reserve some more time.
And that's why I put all the exhibits together, because I couldn't break them out.
And we'll.
And it'll shorten 3, I promise you, when I get through this little scenario.
Well, because you're arguing both of those together, why don't we just go ahead and just take them?
Okay, we can do that. I think that's a good idea. The same thing is true of travel expense. We had a big ordeal over should they have claimed $639 in meal reimbursement or $624 in meal reimbursement over an 11-day period. It's talking about $1.50 a day difference. And the answer depends on which tier you fall into in this policy. Well, in the letters of discipline, it says that you should have only charged meals at the rate prescribed in the location where you spent the night. Well, I don't see that anywhere in the policy. You see, they say that, but the policy doesn't say that. The policy talks about tier 1, tier 2. For instance, to make it clear, if you in New York City, you get more meal reimbursement than you get if you're in Tucumcari, New Mexico. Tucumcari is not the place to stay, but it's something like that. Some place in New Mexico. And it was cheaper, the meal reimbursement was cheaper there. The hotel reimbursements are cheaper depending on where you are. And to say in the charges, and this is why this is important, if y'all will bear with me, why it's important to just say you should have used the location where you spent the night to be the determining factor in the tier. Well, if you're traveling from Baton Rouge and you stop in Shreveport to eat breakfast, stop in someplace in Texas to eat lunch, and then stop in Amarillo to have dinner and have a meal. Which one of those tier, if there are 3 different tier cities, which one applies? I don't know, and I couldn't find it in the policy. So my argument with this, although it sounds like trivial fact, my argument is that they just say in the letter that it should be, you should have used the place where you stayed that night. It doesn't say that in the policy, and we did the best we could. But the whole bottom line, it was $15 over 11 days. Another point I'd like you to make. They make the argument, or they make the charge, that these guys reimbursed, they were questioned about what they claimed. They got paid because the colonel signed off on it. The supervisor signed off on it, the colonel signed off on it. They got paid. After it was challenged, they tried to refigure everything, and each of them submitted a reimbursement. The charges acknowledge they got the reimbursement, but they don't say how the reimbursement was applied or what was going to be. And this is what I think. If we have a reimbursement, tell me, do I owe $1,000 or do I do like Rodney Hyde? Rodney Hyde reimbursed $1,304.90, trying to refigure everything to the best of his ability. They acknowledge the reimbursement. They don't say if it's right or wrong. If they'd have told us how much to reimburse, we'd be saving everybody a lot of time here today. But they didn't tell us that. I don't know if $1,304.90 was the appropriate reimbursement or not. I don't know if the $900 and some odd dollars that Darrell Williams reimbursed is the proper amount or not. But they did. There's nothing in the charge that said y'all made a reimbursement. Again, I suspect Mr. Foss might tell y'all that it's not unusual as troopers travel about that they submit something and they say, no, you shouldn't have claimed this. The proper amount is this. That's why you amend your documentation and submit it. And that's what they tried to do But rather than tell them, no, you didn't recalculate, and you didn't submit the right amount of reimbursement, they just said it's wrong. That's a point I want to make. Another point I want to make.
Aren't many of the points that you're making here going to be extremely fact-laden and fact determinations that we're going to have to make? I appreciate you trying to save us 5 days, but I mean, if we can't make those determinations in advance factually, then
I think you're missing my argument.
Maybe
It might be my fault that you're missing my argument. I'm not. They claim, for instance, I'll just go to the first page of motion number, and no wonder I'm arguing number 3, because I flipped to number 3 instead of number 2. I'm sorry, but if you look at number 3, so we're not disputing that they charge, for instance, at the first page of number 3, hotel charges of $149 plus fees in Amarillo, Texas. What I'm questioning, they said that was wrong, that's an overcharge. Well, what was the right charge? You see, tell me, in my right to have notice, a notice that fully informs me, you claimed $149 plus taxes and fees in Amarillo. I say the right way to charge that is say the state policy or the state police policy would allow you to charge $139 in plus fees and taxes in Amarillo according to policy number XYZ, and you charged $149, they show you overcharged by $10. If you told me that, then I can prepare that defense. But all I have is what they claimed, and they said it was wrong, and I have to assume what is right. That's my argument in a nutshell, you see. To give me a notice that fully prepares, that allows me to fully prepare a defense, tell me what I did and what I should have done and why. And then I can tell you, I agree I did this, but I believe I was entitled to do this for this particular reason. But both 2 and 3 really have to do with the issue of notice and giving me sufficient information to prepare an accurate defense. Another good example, and this is also from 2. They raised some questions about Mr. Hyatt. This is an example about Mr. Hyatt's activity on October 17th. If I can find the perfect page. In his disciplinary letter, it says that on Sunday, October 16th, you were tasked, along with Trooper Negozinski, to transport Colonel Edmondson and others to a luncheon at Torrey Pines Golf Course in La Jolla, California. That's true. Records show that the state vehicle in which you traveled was fueled at 0827. I don't know if that's true or not, but I don't care. But probably is true. You arrived at Torrey Pines sometime between 10:30 and 11. After luncheon, you went with others to the 910 restaurant and bar and George's in La Jolla, California. You returned to San Diego but could not recall the specifics of your activities during that evening. Well, if he was told by the commandant of the Louisiana State Police to drive me to La Jolla, California, and he waited around till the colonel who was in charge of the Louisiana State Police was ready to go back to San Diego, what did he do wrong? I understand what they said he did, but I don't understand what's wrong with that. This is a paramilitary organization. You get an instruction or a directive from your superintendent commandant, whatever you want to call him, and you follow that. Unless you know it's illegal, you are required to follow that instruction. And that's what he did. Well, where does it say that he did anything wrong? They said what he did, but what's wrong with that? What policy did he violate in following Colonel Edmondson's instructions? That's the question I have. I need to be fully informed in order to prepare my defense. What he did wrong. That's an example. I have a whole bunch more examples set out in my motion. I don't want to bore you with the individual facts. But that's an example of what I'm talking about. Give me a reasonable opportunity to prepare a defense by telling me what I did wrong, and what policy I violated. Another good example. Well, this does have we have a dispute as to who told them, did you take the most direct route? Who told them to go where? We have affidavits submitted that the colonel, in a morning meeting on October 10th, if my recollection is correct, at the cafeteria right over the State Police headquarters, told them you need to take the northern route. You need to see the mountains, see the Hoover Dam, see some sights along the way. Have a good time. Multiple people at that table. I submitted 2 affidavits and that was what was said. We received no countervailing affidavits that was wrong. At the heart of this whole thing, there is no countervailing affidavit. I would have never thought we'd have been right for summary judgment on that because I thought they would have some kind of countervailing affidavit. None was submitted. Therefore, you have to accept the affidavit, the evidence you have before you. It's true. I already talked about the restitution. Another big issue in this case, and if you'll excuse me, it's going to kind of flow over to number 4, but I talked to you about February 18th already, as being an interesting date when the actual internal affairs investigation began. What's important, I submitted affidavits, in the letters it says, in the 3 letters, it says, a public records request was made by the guy that usually does the filming here in November 6, 2016, questioning travel expenses and time. That's when all this started, in November 2006. The letters on their face say, in preparing a response to that November 2nd, 2016 request, it came to our attention that there were substantial questions regarding your travel time and your travel expenses. Guess what? These rules of this commission say they have 14 days to start an investigation. The charge is in the letter. I didn't have to produce evidence that on November 2nd that it came to the attention of the officials of the state police. They say it in their own letter. I challenge, we're challenging the legal right to proceed if they did not follow instructions or did not follow your rules. Your rules say once, and I want to quote the rule right, 1218, time within which to initiate. Okay? Well, they interviewed my people on the 20th of February and the 21st of February. They didn't identify who was doing the investigation. I gotta admit, they knew it was Major Flincham, and they knew who she was, but she didn't identify herself. They didn't sign a waiver of rights or a notification rights form. They didn't record the interrogation. We submitted affidavits that the interrogation was intense and pointed. They did all of that in violation of y'all rules. Also violating 40-25-31. On the 20th, after the initial interview with the three people, they went to Mike Edmondson and he said, go back and ask some more questions. So they interviewed him again on the 21st. Now they want to say the investigation started on the 22nd? How many shots did they get at you before the investigation starts? It's a very important point. That's the factual point. Look at the affidavits, look at anything that countervails that. I don't think you can find anything countervailing that. But the whole point is this, and it creates y'all a dilemma. RS 40-25-31 has never been declared unconstitutional as it relates to state police. Whether it is or whether it's not, I don't know. But I respectfully submit to you, five gentlemen, that y'all don't have the authority to declare anything unconstitutional. Only courts get to do that. This may be the case where they get to make that decision. But y'all can't declare it unconstitutional. If you find there was a violation of the requirements of 40-25-31, the penalty provision is nullity of the disciplinary action. Y'all are bound by that until a court says otherwise. Tough decision. I'm not. But bottom line, if I don't point out to y'all very clearly as a matter of law, if you're going to declare something, if you want to declare a statute in the Constitution, you have to make the Attorney General's office a party to that proceeding. You have to have a decision. No decision was ever rendered, to my knowledge, relative to state police. If there was one, I think Michelle acknowledges that in a brief. But in any event, that's a big point of number 4. Very clearly, we submitted the affidavits. Major Flincham is described in the letters as the command inspector. Well, if you got the command inspector asking you questions, you think you're under investigation? You think that's particularly true when there was a public information statement released to the papers that y'all let me put in evidence, saying that on the 18th that they were starting the investigation. They appointed Major Flincham to do it, and she started on the 20th. She questioned him on the 20th. She kept questioning him on the 21st. She didn't record it. She didn't get them to sign the waivers. She did not advise them of their rights. An argument is made in opposition as to whether or not that was a result of, if they suffered as a result of that. I don't know. I wasn't there. I don't know what they would have answered, or I don't know how the investigation was going. But under the law, you have a right to get a counsel. If you are a state policeman and you are being brought under investigation, you have a right to get a counsel. And they can't start the investigation. They can't question you until you get that counsel or waive that counsel, and you have 15 days to do it under your rules, under Party 2531. I think you got 30 days to get counsel. They have to hold up the investigation until you get counsel. They blew that off. I make the comment in my briefing, sometimes I was getting tired probably when I was writing this, but I was a little bit flippant when I said they didn't just ignore some of your rules in Chapter 12 regarding the conduct of investigation. They eviscerated all of your rules in Chapter 12. They violated each and every rule of Chapter 12 in conducting this investigation. A little point for y'all to consider. Did y'all see any countervailing affidavits from Colonel Edmondson? Did you receive any countervailing affidavits from Major Flincham? Did you receive any countervailing affidavits from Lieutenant Colonel Dupree? These are the people that were involved. In his affidavit, David McClendon, I think David is a captain major or something. He's a high-up guy. He said, he admits that on the 20th, they were sent back to Exmoor on the 21st. On the 20th, they were, after they completed the first round of interviews, if we call them interviews, I like to call them interrogation. But after the first round of interviews, Colonel Edmondson sent him back to take some more the next day. So they went back the next day, I think it was a Tuesday, and they asked more questions on Tuesday. No lawyers, no recording, no notification, no identification of who was in authority. I am damn sure they knew Major Flincham was the command investigator, and if she asked you some questions, you better answer. But the law says, y'all rules say, the statute says they have to identify their authority to act on that particular day. None of that occurred. They eviscerated any protections that should have been afforded to these people. I'm not going to repeat all of what I previously said about the notice that went out on February 18th, but I'm going to tell you that you have 30 days to complete an investigation. If it started on the 18th of February, they would have been, 60 days would have run before they asked for an extension of 30 days. And I got all the numbers and the dates and so forth in my motion. Y'all can look at that. But to make it simple, if they had 60 days to start with and they get a 30-day extension, that means you only got 90 days the way they taught us to add in Dowsonville. If we started on February 18th, it had to end 90 days later, even with the extension. That would have been May 18th. When does an investigation end? It ends when the findings are issued by the colonel. That occurred May 23rd. 5 days too late. If you say, well, the investigation, even though the colonel announced it on the 18th, it didn't begin until the 20th or the 21st. The 20th when they did the first round of interviews, or the 21st when they were sent back for a second round of interviews with more pointed questions. Then it was either 2 days late or 3 days late. In any event, it was late. I'm going to digress for a second. On May 21st, they asked for the extension. You know, you got 60 days. On May 21st, they asked for the extension. If it started on the 18th, the extension had already ran. It's too late. The 60 days already ran. You can't wait till it's prescription runs, to use the legal analysis. You have an accident, you got 1 year to bring the accident, you can't wait till I want an extension at the 366th day. The extension wasn't even timely asked for, but I don't want to get too technical there. The whole point is, if you add 30 and 60, you get 90, and they didn't do it in time. So, I suggest there can't be any question that they have violated your rules and the statute when they didn't put people under oath, they didn't record their testimony, didn't advise them of their rights, didn't allow them to get an attorney, didn't allow them the protections afforded by y'all rules. No question they did it. Can y'all say, we're going to disregard 40, 25, 31, and we're going to apply our own rule which says, if we find that there's violations of this rights, we'll decide what's the proper penalty. Y'all might be easy on the administration and say, well, it's going to be something less than nullity. The statute says it's nullity. No disciplinary action can stand if you have violated these, if it's issued as a result of the violation of the terms of the investigation or the rights during the investigation, and that has not been declared unconstitutional. It is binding on this commission. Thank you.
Yes.
It's not an easy argument on the Bill of Rights, but I can make it easy for you today because your rules on summary disposition outline for you what issues can be summarily disposed of, and that's notice and cause. And I submit the minimum standards under investigations does not amount to cause for discipline. It might be a defense to a disciplinary action that is taken by an agency if there's a violation of the minimum standards. But first off the bat, it does not amount to cause for discipline. We cited in our memo what legal cause for discipline is. And it does not state that it's any violation of any minimum standards, whether it's established in the statute or it's established in the State Police Commission rules. So we first argue that that's not an issue that can even be summarily disposed of today. The next thing that we'd like to point out is the agency relied upon the commission rules in conducting the investigation. There was an agreement among the LSTA and the Department of Public Safety that because of, as stated in your rule, the unconstitutionality of the statute's infringement on your constitutional grant of authority as the commission to hear and decide discipline, that the legislature couldn't restrict you. And by saying that the automatic penalty for violation of the minimum standards is dismissal or no discipline can stand, has taken away your constitutional authority. You may not technically be able to declare the statute unconstitutional, but I'll tell you the Civil Service Commission, who has the same statute applicable to police officers under the civil service system, they ignore it. They say that is not for us to enforce. So when they have an issue of whether or not the minimum standards were violated, they don't even consider it in discipline. So that's the first part. It's not cause that would give you the authority to summarily dismiss it today. The second one is you're not bound to follow it, you're not bound to enforce it. You don't have to declare the statute unconstitutional. But in realizing that, the commission years ago, with the cooperation of the LSTA, the Department of Public Safety, and even a member of the commission at the time, sat down and worked out the provisions that state troopers expected to be governed by, and the agency as well expected to be governed by. In regards to the terms of the investigation itself, the investigation began on February 22nd. The one exhibit that you allowed to stay in, the release, by the agency, it's labeled as Appellant B in the conglomerate exhibits, specifically says that there's sufficient cause and evidence to refer the matter to internal affairs for a full and thorough investigation. It first starts, let me start first. The preliminary inquiry has been completed regarding the 4 officers who traveled to San Diego. There's sufficient cause and evidence to refer the matter to internal affairs for a full and thorough investigation. The head of internal affairs at the time was Major Darrell Williams. So certainly the colonel wasn't going to refer to him. What the affidavits fail to point out is on the 19th and 20th, or the 20th and 21st, excuse me, Major Flincham was the head of support services, and David McClendon was not in internal affairs. Major Williams, as the head of internal affairs, answered directly to the colonel. So it's, instead of, we liken the questioning, it was not an interrogation, but very limited questions, 4 questions, on the 20th and 21st to gather background information, was like getting an incident report. If a supervisor would ask an employee to write an incident report to give preliminary information to determine if an investigation is warranted. With that being said, a major who answers directly to the colonel, if the colonel wants to designate someone else to gather the information, he can do that. It was very limited. Once the statement goes on to say that the investigation started, and the date of this article is February 22nd, I have assigned an internal affairs investigator to continue to be supervised by Major Flincham. That's when those people were moved back to internal affairs, or under the auspices of internal affairs, conducted the formal administrative investigation. The troopers were provided notice that a formal investigation began within the time frame. Every interview was recorded. They were given the opportunity to have counsel present, and each and every time they were interviewed, they waived the right to have counsel present. So I can make the leap that at the initial questioning, had it been part of the official investigation, they would have waived the right then also. So we complied with the recording process, and they also complied with giving them the right to counsel. So with the investigation beginning on February 22nd, we point out in the cases here how you calculate the time frame. And the first day doesn't count. I mean, there's cases right on point there that talk about when you initiate it, you don't count the first day. So in counting the 60 days, the department did complete the investigation timely. They requested the extension of time timely. And the notice provided of the decision was given on May 23rd. I'd like to point out also that in requesting the extension of time from the troopers, they all signed a document stating that they were voluntarily agreeing to extend the time. And that document states clearly the investigation began February 22nd. It stated when the 60 days was and when the extension would be through. Nobody questioned it. Nobody disputed it. Nobody refused to sign it, because if they refused to give the extension of time, the department could have come to the commission or the executive director and asked for an extension of time. And the department relied on those employees' voluntary extension of time. Also, even if the time to complete the investigation had expired, I don't think it's a prescription issue. There's nothing saying, in fact, the rules say the employee can give a voluntary extension of time. So even if it was 2 days late, there's nothing that prohibits an employee from agreeing you can have more time to complete this investigation. So the extension was timely, but even in the event that it wasn't, there's nothing that prohibits, by the agreement of the parties, to allow the investigation to continue on. I provided cases for you that show that the Civil Service Commission does not take the Bill of Rights into account. And I'm going to caution you here that the absolute nullity provision in the statutory Bill of Rights gives the head of an agency who's bound by that a whole lot of discretion and a whole lot of power. Because any person in the rule that says if the commander above knows of an incident, and we have to keep in mind that it's not just something happened, it's getting the information to determine, does this warrant an investigation? All you have to do is wait till that 15th day and then say, oh, it's not timely, we can't do anything, can't take any action. I don't think that's what the statute really implies there. So that understanding that penalty is not the appropriate penalty, this commission decided that if there is a violation, and we still say if because that hasn't been established yet, I don't think they've met the burden of proof of showing that the minimum standards weren't followed. But if it's violated, this commission has the opportunity to decide, how was the employee prejudiced? How did it impair them in forming their defense? And you get to make the decision what penalty, if any, should be imposed for that violation of the minimum standards. That is very strict, and as far as 60 days to conduct an investigation, I'll tell you, it's hard to do. And that's why there's a voluntary extension provision, as well as the opportunity for the agency to ask the commission for additional time. That's what was needed here once the investigation started. The employees agreed to it, and the department submits that the minimum standards were followed in this case.
Well, I'm pretty surprised that the Office of State Police would come here and say, ignore a statute. That's all I'm going to say about that. I'm also surprised they would say, well, another commission ignores statutes, so it's okay for y'all to ignore statutes. I asked the 5 of you individuals, can y'all ignore statutes? I mean, y'all have to decide that. I would be a little hesitant to suggest that you would think that you could ignore a statute that's specifically on point. Whether it's a good statute or not, I have my opinions on that, but no court has ruled on that. Now, let's talk about when this thing started. On the 20th, this is, I'll refer you to Exhibit U. There's 2 parts to Exhibit U. On the 22nd, there was put out the Colonel's secondary statement. It says in the original statement from Edmondson, which can be read below, you can see that on the first page, the original statement, which was on the 20th, reads as follows. In response, I've directed the following steps to be taken by the department. Number 1, Major Kathy Flincham, Patrol Region 1, Command Inspector and former Internal Affairs Commander, is conducting an administrative investigation to determine the violation of departmental rules and policies. How can it be more clear than that? Major Darrell Williams has been reassigned from Internal Affairs. He got bumped from his job because somebody else was going to do it so they can investigate him. You think the investigation started? Sounds like it to me. Management and finance is taking steps to recoup the money paid in overtime and reclassify any earned time as compensatory time. Sounds like investigations underway. Hotel fees and per diem claimed in Las Vegas will be repaid by this paid to the department. Sounds like to me something's up. We are changing policies to reflect that paid overtime may not be claimed for travel to a conference, etc. On the 20th, the colonel is telling you exactly what he's going to do. The investigation has been initiated, but before he even got the results, they were taking steps to recoup money. They wasn't going to allow any charges for hotels in Las Vegas, and they were going to change their policy. Not only did the investigation begin, he already determined what the outcome was going to be. I think it's ludicrous for somebody to suggest to you that 2 days of interrogation of 5 people are similar to asking an officer to write an initial report. Let's think about that. Was an investigation started or not? Seems pretty clear to me. The LSTA doesn't have a collective bargaining agreement with the Office of State Police. I represent 3 individuals. 3 individuals who stand under their rights under RS 402513. That's what we stand. And y'all don't have the authority to declare it unconstitutional. You have to grant this motion, and you have to let the courts decide. You got to grant the motion. You got to go by the statute. You cannot declare it unconstitutional, and then the courts will get their chance, one way or the other. Thank you.
You don't have to grant the motion if the facts don't support what is alleged. So first, it's not cause, so it's not right for summary disposition. And second is, we're sitting here arguing over when the investigation began. So if that's not a material fact that you want to hear, I mean, what is? So a hearing on the merits is where you decide those issues when they present it as a defense to the discipline.
That's the conclusion of the motions?
It is.
Thank you.
Time for lunch.
That's great. We're gonna have any other commission business? Nobody's brave enough to say that. We'll move on to a very quick director's report.
Absolutely. I just wanted to advise, as you mentioned earlier, that we have relocated into office space here in the building effective May 1st. And I want to thank everyone at the Department of Agriculture and Forestry that worked so well with us and assisted us in making new as efficient as possible. We've truly been welcomed into this new location. So, and additionally, your budgetary expenditures have been within the binders, and that's
All right. I take it we have no comment cards that have been submitted. So, having none, I'll entertain a motion to adjourn. So move. So you get about 5 seconds on that one. All in favor, say aye.
Aye.
Opposed? Thank you.
Is this?
I'm exhausted.